By virtue of Article 15 Clause 5 and 15 Clause 6, reservation can be provided to students from economically and socially weaker sections of the society. Can such reservations be implemented in private law colleges too?
Actually, in our system, we have an inbuilt mechanism for the weaker sections of the student community, wherein the sufficient monetary support is given by the colleges already. That is, students from economically and socially weaker backgrounds, they have already been given under our government law colleges. But when coming to this position to continue in private law colleges, see, we can refer to the decision way back in TMFI case and also in the Mandal Commission, wherein the Supreme Court itself has said that reservation cannot be extended to private institutions. See, by that decision itself, the what do you call, education has been commercialized. If you pay money, you get into a good law school. And whether, see, unless and until the government is in a position to substantiate and aid the law colleges, the system, that is, in my opinion, the reservation cannot be carried out in private law colleges, because the establishment, the continuation of the establishment with the faculty and the infrastructure will cost a huge amount. And if the government is not able to aid the establishment and maintaining of the private colleges, do you think that the private colleges will be able to implement the reservation there? That is something out of the box thinking. And so I think that cannot be carried out in private institution. But now we have implemented that 50% reservation in for students in the merit category without paying capitation fee, etc. If that is continued, that itself will be sufficient for the improvement of the economically weaker sections of the society. Thank you.
My next question is, how can students convert their theoretical knowledge into practical purposes for aiding the society?
That is a very, very valid question. Actually, the students have to convert their theoretical knowledge into practice. And what we learn in the law college, or the theory part of the law, which we have the exams, the assignments, the internship, etc., that it's not sufficient for helping the students with their professional skills. Practical training is compulsory for a good lawyer. And this aspect has been discussed in many platforms. See, once you come out of the law college after a 5-year LLB or a 3-year LLB, you cannot directly go to the court and start your practice because you don't have sufficient practical skills. So the theoretical knowledge is not sufficient for entering the profession of law. So that aspect has to be taken into account either during the academic course of the student or after completing the course. So this was one aspect wherein the Bar Council of India said compulsory internship and passing of an exam to be enrolled as an advocate. See, earlier there was the FL and the BL, the first year in law and BL, and 1 year compulsory practicing under a senior lawyer for 1 year, and then writing an exam, then getting enrolled. But after that, we started this 3-year LLB and the 5-year LLB. So, wherein the practical training was given along with their academic theoretical exams. Now, many time we have found that this is not sufficient training for the students to enter the profession of lawyering. So, as I said in my introductory speech, it is highly essential that 1 year compulsory training should be imparted before they enroll as a lawyer. And this should be taken into that is seriously by the academic, that is the colleges itself. See, after completing the course and LLB and getting a degree in LLB, he will not be interested in doing any practical training after that. So, just as in medical colleges they do, they have to be subjected to 1 year or 1.5 year compulsory internship before they are conferred with the LLB degree. And that will be a good beginning to imbibe the professional skills. And that is my opinion as far as the theoretical aspect, that will be more helpful for the students in aiding the society.
Okay, ma'am, thank you. So my next question is, legal education often limits itself within the theoretical method, that is the lecture method. What about other learning methods such as the Socrates methods or the problem solving method?
See, this question is often confused. And when we research into what is the object of legal education. So, when we go for a PG degree in law, that is LLM, the object of a PG degree in law is for teaching or doing some research. But what is the object of legal education? Legal education is either get into the profession of a lawyer. So, as I referred earlier, the traditional method is lecture method. See, that method cannot be totally taken out of the course. That is highly inevitable, because to understand the fundamental principles or the basic principles of law or the theory of law, that is jurisprudence and the fundamental criminal jurisprudence, etc., the lecture method is necessary. But since the technology has developed in a large scale and we are bound to keep pace with that development, we have to introduce innovative methods into our teaching methods of law. And especially these principles and all, see, whatever, instead of hearing or digesting what a lecturer gives you, sometimes you forget after that lecture. So, seeing is believing, they say. So, when you see something on the screen and you note down the points, I think that will be more clear in the mind of the students. So, technology has to be included in our curriculum, that is in our method of teaching, wherein you jot down the principles and you also highlight the facts of the case. See, other methods such as case method, discussion methods, debate, etc. are there, where the students also get involved with the teaching, with the teacher, such that they also get prepared with that subject. So, sufficiently early you give the students that you are going to teach a particular topic next class, and ask them to get prepared with the case laws in that particular area, and involve the students into a discussion method or a problem method, and such that their mind also get activated and get actively involved while the teacher gives out the basic principles or the fundamental principles. So it is a long overdue that you mix lecture method with other innovative methods to include or involve the students also in the process.
Do you believe that Bar Council of India is effectively fulfilling its role in enhancing the legal education system of the state of Kerala?
Definitely not. I have a very right grievance against the Bar Council. They are not at all doing what is expected of them. They are not fulfilling their role effectively. That is, the Bar Council of India is not interfering to improve the legal education. They are not giving proper guidelines to the law colleges as to how to improve the standard of legal education, how to instill professional skills in the students. See, the Bar Council of India can take initiative in bringing eminent lawyers from the Supreme Court and the High Court to various law colleges to teach the students as to the procedure laws, the civil procedure code, the criminal procedure code, and how evidence is taken, and what is the role of forensic science in collecting evidence. See, these are matters, or these are areas wherein the Bar Council of India can play effectively in improving the standard of legal education. And the Bar Council of India is utter failure in that aspect, such that they are just a machinery to giving recognition to the colleges and enrolling the students. They are not at all doing their role effectively. That is a grave grievance I have against the Bar Council of India. Instead of giving dictations as to what kind of course or what kind of syllabus should be added in the academic curriculum of our law colleges, they should concentrate on how to improve the skills of the students after they pass out. And that role the Bar Council of India is not fulfilling, or not giving any importance as to, and that is one of the reasons for the deterioration of the lawyers' ethics in the profession, which we see nowadays in the courtrooms.
Okay, ma'am. In your opinion, as the former principal of 3 government law colleges of Kerala, how much have legal education system evolved over the years?
See, when I started my and we had around 100 students in the class, and only 10 girls and 85 boys admission class, and 15 students, 10 or 15 students, girl students in the class. And at that time, if we select around 5 to 6 descriptive questions, we study that, we write the exam, we get a degree. But now we have internals, we have assignments, we have adalats, we have mediation, we have arbitration, we have to study professional ethics. So many changes has been brought about in the curriculum as well as in the syllabus. So rote learning definitely has come to be minimized compared to our system way back in 1978-80. But the infrastructure in the law colleges is the same as in the 1980s, even now. So, as a principal, I had worked as principal in Law College Thrissur, Law College Ernakulam, as well as Law College Trivandrum. And one thing I want to tell you is that the students who come to the colleges, 80 to 85% of the students are interested in improving their knowledge and getting a good degree, they have in mind career prospects. Around 5 to 10 percentage they come to the college for political improvements. They are not coming to study. So in my opinion, I had great difficulty in managing academic as well as these political activities, especially while I was serving as a principal of Law College Ernakulam. Because, see, many of the students come to the campus with high hopes, getting a degree and be a lawyer. But often, when their dreams are not fulfilled, the very track in which they are traveling is shifted. And as such, they also get wavered and they join the other bandwagon, which is not studying. So you can say that they are passive students. They are neither interested nor interested in politics, but the effect is the same. So I want all the academic authorities to take initiative to carry out only academic activities inside the campus. That difficult. That was something which I had to face gravely when I worked as principal in all the 3 law colleges. So politically motivated students are good. Even in the constitution, it says that freedom of speech, freedom of expression, you express your freedom, you express your rights. But here only rights are expressed, not duties. What is your duty as a student? That is not done. And so political activities are good. See, even in nowadays, when we studied, political activities were there, but there was no destruction of public property or questioning the authorities. But nowadays, they are destroying public property and they are also questioning the authorities, the principal and the teachers. And such that their morale is down. So the teachers have a fear while teaching. So that is one bitter experience I want to share with you in this platform. That is, in Kerala, the political system in the law colleges is very much affecting the academic, dream of a student. So that should be curbed. And that should be taken seriously by the authorities. That is why nowadays even the High Court has come out with rulings. That is 90 effective days for conducting the exams. So if you lose one working day due to Bandh, Hartal or a strike in the college, one working day is shifted to the next day. So there is a lagging coming in the passing out of the students. 5-year course will be completed only after 6 years. 3-year will be completed only after 4 years. And exam system is another thing which is affecting the future of the students. So the exam also has to be corrected in such that exams are conducted in time and not postponed. And a student expects the course to be completed within that 5 year. Then only it can be of any use to him. So I am really happy that I could serve as principal of the law colleges, and I had great experience as principal of all the law colleges because I have been able to do good. Means I could do much to the student community as a principal by enhancing their academic activities and also conducting debates, moot competitions, and also many national, international seminars, which was of use to the students as well as the teaching community to enhance their knowledge in the developing legal fields. So, thank you.
Thank you, ma'am. With this, we are concluding our interview. I express my heartfelt gratitude towards Saroja ma'am for sharing her valuable insights on the topic. It was indeed an enlightening session. Thank you, ma'am.
Thank you.